Welcome to Money Justice Inside the Courtroom with Tim Felice.
Hey everybody, welcome back to an all-new episode of Money Justice Inside the Courtroom with attorney Timothy Felice. I'm your host, Mike Leon. Tim here is the founder of Felice Trial Attorneys. It's a Florida-based personal injury firm. They're known for taking on serious and catastrophic cases in the courtroom. He's got more than 20 years of trial experience. Tim's been dedicated to securing full justice for those that have been harmed by negligence. In today's episode, we're going to really explore and break down what persuades a jury. You may have seen Sam Waterston do this on Law & Order. Tim does it a little bit better. We're going to talk about the mix of psychology, storytelling, and the authentic connection that turns facts into verdicts. Tim, it's good to see you. I just alluded to Sam Waterston on Law & Order. So every time people, I guess, associate, you go on it, you see the TV shows, you see the lawyer try to make a connection with the jury. When you're in front of a jury, what's the first thing you focus on to try to build that connection?
Thanks for having me, Mike. Thanks for comparing me to Sam, too. He's a good character. Whereas they have scripts, we don't really use scripts here. But when it comes to building connection, the biggest thing you have to do is just be yourself. Don't be a robotic lawyer. When you're talking to a jury, so the first time I get to stand up and talk to the jury is during jury selection. And that's my opportunity to learn about them, about their opinions, their beliefs, who makes them who they are. And they get to see a little bit about me. And what you really need to do is you make sure you listen. You got to pay attention. You can't have in the back of your mind, you got another question. You have to listen to the answer. You got to feel it. And you got to, give that person grace and thank them for what they're doing. And it's really just about being yourself.
Yeah. You want to practice, but you don't want to sound rehearsed is something I always say. So let me ask you on that vein, how do you help jurors during the process? How do you help them empathize with what your client's going through instead of just hearing the facts of the case?
That's a really great question, because in Florida, we're not allowed to say to the jury, hey, how would you feel if someone smashed into you and killed your best friend and made you have 16 surgeries? How much would you want for that? We're not allowed to do that. We're not allowed to ask them to put themselves in the position of the injured person for purposes of figuring out what the value of those injuries are, right? So when it comes to having them empathize with our clients, with what's going on, we can't just stack a fact. We can't just say, this is what happened on this day at this time, and this is what we want. We try to create a story for the whole trial, a true story about what happened, and not just saying blanket statements like, oh, I'm really hurt and I can't do laundry anymore. Or, oh, I can't go do anything with my kids anymore. We bring out actual stories, examples, real life examples of what they've been through. I remember asking a client once, she tells me, well, it's just a lower back injury and surgery. And she's like, I have a hard time doing laundry. I'm like, all right, well, that might, jurors may connect with that, may understand because they do laundry, but that doesn't really help, right? So I explained, we need a story. Tell me the last time you had a problem with doing laundry. She tells me, oh, Tim, a couple of weeks ago, I was doing laundry and I had, one of those stackable washers and dryers. The washers are on the bottom. And she's like, I'm kneeling and I take the stuff out and I stand up and I put it in the dryer. I do it a couple of times. Now, mind you, she's like 5 foot. So she's a tiny, tiny woman. And she's like, I still at the back of the drum in the wash machine, there's like underwear or socks or something. So she's like, I get down on my knees and I reach in to get it and my back locks up. And she's like, I couldn't move. My head was almost inside the washing machine. And I was screaming for my husband, come help me. He comes in at the corner of my eye. He comes in through the door and he starts laughing at me. And I'm like, what are you laughing about? I'm in pain. He thought I was joking. I wasn't. I had to go. He came over. He kind of picked me up. He helped me stand up. And she's like, and he carried me in bed. And then unfortunately, I was in bed for almost a day and a half because my back hurt so bad. And then I went back to the doctor. So I was like, well, that's a perfect example of what I was looking for, right? So we try to do it by telling the stories of what occurred, what's occurred in the past, and then we try to highlight what those changes in life have become. You know, what was taken away from that person, what they're ultimately left with, and we try to do it in a story form so that people can understand and something that they'll remember when they're deliberating about damages in the jury room.
Not only that type of example, but I'm sure visuals also help play a big part and role in the courtroom. What do you think makes for an effective courtroom exhibit?
Visuals are incredible, right? When we want to tell stories, we don't want it to just come from our voices. We want it to come from our faces, our body, our expressions, and what we do, and we want to tell it with pictures and images if we can. So we will use models, spine models, brain models. I actually went so far as one time I had my client's lower back. It was a high image MRI. I had his lower back 3D modeled and created so that we had a physical 100% accurate replica of his lower back that we were able, it was magnetic. We pulled it apart and inside it looked exactly like how the MRI was. And then I had another one built that didn't come apart, and I paid a surgeon to implant the same hardware. Well, my poor client, he was in his 30s and had a major lower back surgery. Visuals are great. And this one, we used this guy in trial in March. And this is a very simple exhibit or demonstrative aid we use. But it was so powerful because our client had suffered so much over the past almost 10 years. She had multiple surgeries. We were able to use this, and I went through it with our experts, highlighting every part of her body with red tape to illustrate exactly where she was injured. And then we also wrote down the amount of times that each body part had surgery. It was very powerful. The jury was able to see it in real time as I'm putting the stickers on, and we're talking about her elbow surgery and wrist surgery and her neck surgery, and can't really see the top of the head, but inside that skull is red tissue paper because she had a brain injury. So we pulled the skull off, and I put the tissue paper in and closed it. And then later on, when we're talking to the jury in closing, he'd said, remember when you'd see me do all of these things? And I said, remember, there's red tissue paper in there in the brain. And I put that in there to illustrate just because you can't see it doesn't mean it's not there. And there are invisible injuries that happen, especially inside someone's brain. So the red paper is in there. You can't see it, but she feels it. So no, you need effective, good visuals in trial.
Yeah.
Everyone should have something.
Tim, a second ago, you talked about how in Florida you can't do the whole "how would you feel" type of argument. But I'm sure there's some trial lawyers, not only in Florida, but nationally, that once they start talking, they talk about preconditioning jurors before the evidence part of this, rolls out. What does that mean for folks out there who don't know what that means? What does that mean in practice? How do you approach it ethically?
We don't do it. You're not supposed to do it. And at least when I try cases, and the lawyers that have taught me to try cases over the years have told me, you don't do that. Don't try to precondition. Be yourself. Tell the truth. We use brutal honesty from a great trial lawyer, Nick Rowley. We use that in jury selection. We talk about brutal honesty, and we just talk about the pertinent points. So for me personally, we don't try to precondition the jury. Other lawyers do. And in some states, they have more leeway in certain things that they are permitted to do and say in front of a jury that we can't in Florida. But preconditioning is when they're trying to almost pre-try their case. They're trying to find the jurors or instill in the jurors some sense of feeling so that before they end up on the jury or in the jury box, they are already siding with one side or the other, or at least in the back of their mind, they have a leaning. And that's not the purpose of jury selection. That's not the purpose of voir dire. We are looking for fair, unbiased jurors for both sides. During jury selection, sometimes I will make sure I call out people that'll be too favorable for the plaintiff and have them stricken right in front of the jury. I will tell them that it's not like what you see on TV. We're not looking to stack a jury. I want people that are completely fair and unbiased. And let's say I have somebody who had a prior motor vehicle crash or they had a family member that was killed in a crash. I'll actually ask them, would it really be fair for you to sit on this jury? Would it be fair to the defendant? Like, no, it wouldn't be. So preconditioning is not supposed to happen. Like I said, so we don't do that, at least not intentionally.
Yeah. Speaking of not intentionally, you train lawyers. So I'm curious, what skill have you seen in your years of training lawyers? What skill do you see them most struggle with at first with respect to, whether it be making that connection with the jurors, et cetera?
Eye contact and being themselves. Every single, and I was guilty of it too many, many years ago. And it takes time to get comfortable in front of talking to strangers. But the best thing that a lawyer can do for themselves is to learn how to be the same human being in the courtroom as they are anywhere else in their life, right? You want to talk to jurors as human beings. You don't want to be a lawyer. I see so many young lawyers, they write scripts out and they stick with the script and they memorize the script. And then if something goes wrong, if something is out when it comes to scripts, they lose it. They don't know how to respond. They don't know how to pivot and do something else. But if they're just themselves, if they can relax, they can be in the moment and they can just be themselves and listen to whatever gift they're being given by that juror or they're a witness, the judge, defense counsel, whatever it might be. They have to be able to be themselves and it has to come out naturally. Right. And the other big thing I notice is that a lot of young lawyers and a lot of people in general, especially the younger generations, they have a difficult time maintaining steady eye contact. Now, when you're telling stories and you're actually like reliving an event, you're not going to look in someone's eyes because you've got to be inside your brain and experiencing and seeing what's happening. But when you're just talking and when you're learning about people, they don't hold eye contact. And if people don't hold eye contact, it makes people struggle and maybe they're less sincere, or not even that they're less sincere, that they're just not as confident in themselves, in their client, in the case, in whatever they're arguing. And that one thing you have to be is confident. Don't walk into a courtroom if you don't believe in your case. Get someone else to try it.
Tim, I want to stay on that because especially throughout the course of a trial, things can change in a heartbeat, right? Yeah. So what helps you think on your feet, especially when the unexpected happens?
I mean, I've learned over time to slow down my pace. I'm sure you can see sometimes I talk really fast. I try to be mindful and talk slower and using silence. The most powerful tool in the courtroom is silence. So if something happens that is somewhat unexpected, whatever it might be, I try to not immediately respond. Try to take a moment, process what's going on, And in my mind, I mean, I'm probably trying to think of 2 or 3 different ways to handle whatever the situation is. But I take that moment, and then once I decide on the final whatever I'm going to do in that situation, that's when I do it. Whether it's standing up, whether it's talking, whether it's keeping my mouth shut and sitting down, I try to do that. If you try to immediately answer immediately or try to pivot quickly, and it's not something you've done in trial before, if you're not seasoned, it's going to be a problem. And I've seen that happen, unfortunately. I had tried a case with another guy who had a handful of trials, and he just kept getting stumped because he tried to do something he saw me do with another witness earlier in the trial. He tried to do it with another witness doing the same thing, but it was the first time he'd ever done it. So there were objections, there were curveballs, and he didn't know how to handle it. So that's another thing. Usually there shouldn't be that many things that happen in a trial that you don't reasonably anticipate. There really shouldn't be major surprises. That's the purpose of discovery. So the one thing we would always do is if we're going to try something new, we don't try it for the first time in trial. We practice it, we learn how to do it, and we think about other things that may happen. How do we get this into evidence? What types of objections might we have? So this way, if something does get derailed, or it's possible the train's going to go off the tracks, we might already have it in our mind what we want to do if that actually occurs. Kind of a contingency plan.
Right. Tim, as we wrap here, for other attorneys, maybe they're listening to this, they want to become more effective in front of a jury. One change that you would advise them that they make today before they start their next trial that would have a huge impact?
Oh gosh, just one thing that they could change. It still goes back to they got to be themselves. I think we may have talked about it in the past. Jerry Spence, I got his quote on my wall. You cannot expect the jury to do anything which you yourself will not do. So you need to put yourself into your client's position, but you need to learn to be able to communicate and just be you, not be the lawyer. Stop the legal speak. It's not the automobile was traveling northbound on Highway 867. It's Bob was driving his Dodge Ram north on 857. You have to be yourself. Stop being a lawyer and go back to being a human being, because we're human beings first.
Human first. I couldn't agree more. Tim, thanks as always for the time and insights. Appreciate it.
Oh man, thank you for having me. It's been fun.
And thank you to everyone out there listening to this installment of Money Justice Inside the Courtroom with Timothy Felice. Look, winning a jury's trust takes more than just evidence. It takes honesty, preparation, respect for the people hearing the case, and you got to be a human being. To learn more about Tim's work, the results that he's had in court, do me a favor, visit injurytrialattorneys.com today. Don't forget to like, subscribe, leave a review and comment, or share the episode with someone who needs to hear it. As always, I'm Mike Leon. See everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.